My name is Catherine Barnett. It's my pleasure to welcome you on behalf of Chillicothe Public Library to tonight's presentation on this is not family law. Tonight is criminal records relief with Denise Conklin of Prairie State Legal Services. This is the third and final conversation on legal aid topics that we're hosting this summer. Tonight's program is being recorded, and recordings of all three sessions will be available to view and share from the Chillicothe Public Library Facebook page. Before we get started today, I do have a few housekeeping items. If you hover over the Zoom screen, you'll see a series of tools at the bottom. You can click on chat to comment or interact with each other. To view automated closed captioning, please click on the closed captioning live transcript icon at the bottom of the Zoom screen and select show subtitle. If you wish to hide the subtitles, click the icon and select hide subtitles. The presentation will be about 30 minutes, followed by a time for questions. Please use the Q&A tool to submit your questions. And you can also use the raise hand tool to indicate that you have a question, and I will unmute you so that you can ask that. And now it's my honor to introduce our speaker. Denise Conklin is managing attorney for the Peoria-Galesburg office of Prairie State Legal Services. She began her career at Prairie State as a volunteer attorney in the Peoria office in 2004 and became a staff attorney in 2007. Denise became managing attorney in 2009. Prior to joining Prairie State, Denise worked as a senior associate in the litigation department at the Catton Muchin Rosenman law firm in Chicago. She graduated magna cum laude with a Juris Doctor degree from the University of Illinois College of Law and is admitted to practice law in the state of Illinois and in the United States District Court for the Northern and Central Districts of Illinois. Her practice focuses on all aspects of poverty law, including family law, government benefits, education law, and housing law. Denise Conklin, welcome.
Thank you. Thank you for having me. Thank you to the Chillicothe Public Library. Thank you to Catherine. I appreciate this opportunity to share information about Prairie State Legal Services and the work that we do on behalf of the community. So again, my name is Denise Conklin. I am an attorney at Prairie State Legal Services. I manage the office currently. Our office is bigger than just Chillicothe and Peoria. We actually serve 9 counties. So part of this outreach is I would like to share with everyone the scope of our services so that if you or anyone in your life that you encounter has a legal issue like this, you will think of Prairie State and refer that individual to our office. So our office is one of 12 offices of Prairie State Legal Services. We serve Central Illinois and Northern Illinois, but not Cook County. Southern Illinois, which would basically be Springfield and Champaign and South, is served by an agency called Land of Lincoln. Prairie State Legal Services covers basically Peoria, Bloomington, Kankakee, and all of Northern Illinois, but not Chicago. As far as our office, we're one of 12. We cover 9 counties in my office, which include Peoria and Tazewell County, and we go up Marshall County and Stark County, and then over to Galesburg in Knox County, Fulton County over by Canton, and then over to Henderson County and Warren County and McDonough County. So that entire footprint is our Peoria-Galesburg office. And so if you know of anyone who has a civil legal need, like I'll be discussing today, please don't hesitate to refer them to our office. I saw that Catherine put Prairie State's website in the chat. That is an access point to apply for services right there on the website. So that would be a good place to go. And I also want to encourage folks to access our services through 211. It's kind of like dialing 911, but you call 211. That's a service that our local Heart of Illinois United Way puts forward for our community so that if people have questions about different support within our community, whether it's getting legal aid or housing or food shortage issues, people can call 211 and they'll talk to an operator who will share those resources with the caller. So what does Prairie State Legal Services do? We are the community legal aid organization. We provide free civil legal services to low-income individuals in our office. We provide advice and we also provide representation by an attorney in administrative hearings, in court hearings, any type of hearing setting. We pay our bills through grants and private donations. And what we do is we provide a voice to people who would otherwise not have a voice. You all, I'm sure, are familiar with the Pledge of Allegiance that we say in school, and it ends with, "and justice for all." And that's the idea, that regardless of income, everybody will have a voice in the court system and be able to communicate their needs, their defenses, their claims to a judge. We only help with civil legal needs. We do not represent folks who have criminal cases. If they've been arrested and they're before the judge on a criminal matter, that's not anything Prairie State can help with. We only help with civil issues. And so to talk about that, let me share the types of cases that our office handles. And I've shared this on other screens and we've focused on different issues, but again, there are four. The first one would be safety cases. We represent individuals who are victims of child abuse, elder abuse, domestic violence within the home, neighbor to neighbor abuse, school bullying, any type of safety issue, we will help. We help with the emergency issue, and we also help with the more permanent solution. And that might be a custody matter or a guardianship or a divorce. Our second area of practice is housing. We assist where someone is being wrongfully denied housing. And it literally can be any type of housing. It can be a nursing home discharge where a senior or a disabled adult is being removed from a nursing home or an assisted living facility wrongfully. We will help. We help with foreclosures, rent to own, contract for deed type of arrangements with housing, and also basic landlord tenant we will assist with. Currently, there is still the eviction moratorium due to the COVID situation in our country. That has had many different looks and approaches by both the federal government and the state government. If you are interested in learning more, I would encourage you to go to Prairie State's Facebook page. On Thursdays at noon, we actually host a Facebook Live presentation every Thursday at noon to talk about the current state of the eviction moratorium and what landlords and tenants, what their rights are, what their responsibilities are, and what the law currently says. Individuals can still be evicted under the current eviction moratorium if certain criteria are met. But there are also a number of situations in which a tenant cannot be evicted right now if certain criteria are met. And that is generally because of what's going on with the COVID pandemic. And so if you are at all interested in that, in understanding more what the current state of the law is on the eviction moratorium in Illinois, I would encourage you to go to Prairie State's Facebook page at noon on Thursdays and listen in to that Facebook Live presentation. So the first area of our practice are safety cases. Second is housing. Our third area of practice is public benefits. And the public benefits, thank you, Catherine, appreciate you putting that in the chat. For public benefits, what we are talking about is where an individual applies for our services who is being wrongfully denied a government public benefit. And it literally can be any type of government public benefit. It could be veterans benefits, unemployment, food stamps, SNAP, DHS type benefits, Medicaid, Medicare, special education services in schools we assist with, and Social Security disability, SSDI or SSI is a common area of our practice. And in that area, Social Security disability, those individuals whose cases we take on are being wrongfully denied SSI, Supplemental Security Insurance, or Social Security Disability Insurance. And in those situations, the individual is found to be too disabled to work. So in our country, it has been decided that we do not want our disabled people without any means. We have this minimum level of government assistance between subsidized housing, link benefits, so food stamps, and Social Security benefits. An individual who is too disabled to work and doesn't have a family to support them can live in safety and in a dignified way. So that's our public benefits area. And then our fourth area of practice, which is really what I'm going to talk a little bit more about today, is our ready to work practice. So we're under public benefits. We assist individuals in a variety of government benefit cases, but also if they are too disabled to work. Under our ready to work program, our fourth area of practice, under the Ready to Work program, we assist individuals who want to work, but there is some sort of legal barrier that's preventing them from getting employment. And we wrap around those folks and help them move from a place of unemployment to employment. And that really gets to the heart of what the point is of legal aid. Legal aid tends to be a bipartisan supported program, meaning that there is wide support for legal aid. And why is that? Well, not only do we provide a voice to individuals and access to justice, but we also help with poverty alleviation. And that's something we're going to talk about today a little bit in this fourth area of our practice, the ready to work practice, how we help folks who are underemployed or unemployed to get better jobs. Okay, so looking into that specifically, there is the law on ready to work is, there are several different laws that are in play, but one of them is the Illinois Criminal Identification Act. And that has been passed and amended several times over the last few years with the idea that if somebody has criminal records from the past and they have paid their debt to society, that that's not meant then to be a life sentence for them, but that at some point they'd be able to move past those criminal records to gain employment. And so I just want to share this with the audience so that if you know people in your life who had a past retail theft conviction, for example, or a past battery conviction, for example, and years have passed, and we'll talk about that waiting period, please, and they are finding that that criminal record is a barrier then to getting a job. Please refer them to Prairie State Legal Services. We help folks identify what's on their criminal record and then the legal process to have the record, and some of the words we'll talk about are expunged or sealed or obtain a healthcare worker waiver. So under the Criminal Identification Act in Illinois, there are a number of things that folks can do to either expunge or seal their record. And basically, it falls into a couple of different categories. And expungements and sealings are very similar in that when a judge agrees to expunge or seal a record, it's removed from the public, kind of the public, and employers or landlords or the public in general wouldn't then see those records, with some exception. With sealings, and we'll talk about those in a moment in more detail. If there is a felony conviction, then certain employers still can see those records. And that includes any employer who is required to do fingerprint background checks, which includes all of your medical employers, the hospitals and at the nursing homes, home health, and so forth, doctor's offices, and also at the schools, park districts, are those types of employers that are required to do the background checks. But for most employers, once a judge seals or expunges a criminal record, that record is no longer in the public, and it really helps folks get jobs and move past those past incidents where they've already paid their debt to society and are now trying to move forward. There are some criminal convictions that you cannot seal or expunge. The way the Illinois legislature has passed the law, they have specific criminal convictions that cannot be sealed or expunged. And those do include DUIs. You cannot do anything to seal or expunge a DUI. It also includes your sex offense types crimes. You cannot seal or expunge those. And it also includes your domestic violence type crimes. You cannot seal or expunge those. It also includes harm to animals. So if somebody has been convicted of that type of crime, you cannot seal or expunge those types of records. So for the expungements, we're generally talking in situations where somebody has been arrested, but they were never charged, or they have been charged and found not guilty, or they went to court and they were given a determination of supervision or certain qualified probations. And if they successfully completed those, then a record can be expunged, which is basically impounded from the public record. A sealing is generally for all convictions. If somebody is arrested and charged and they go to court in a criminal case and they were found guilty and they were sentenced to a fine or sentenced to jail time or sentenced to conditional discharge, any type of sentence in a conviction, then you're talking a sealing. And again, when a judge seals a criminal record, it is also removed from the public, unless, as I said, it's a felony, in which case certain employers that are required to do fingerprint background checks, they can still see the felony convictions. So when I say that a record has been removed from the public, sometimes people wonder, well, is it like a magic wand where it's just never happened? The conviction never occurred? And that's not the case. And I always try to emphasize that with clients, that by expunging or sealing a record, that record can still be viewed by law enforcement or by the court in the normal course of their business. So it is helpful to remove it from the public record so that you can move past it to get jobs or get an apartment. But I never want people to think it's completely gone, because it certainly can come back, especially the sealings, particularly if there are subsequent criminal offenses in the future. But they really are meant to help people have a second chance so that they can gain employment. So one concept I just want to share with everybody is the concept of a waiting period. And after a case is finished, whether it's in the expungement area, say you get a person was adjudicated and given, or they've gone through the criminal case and they received supervision or qualified probation. Once that ends, that starts a waiting period. Similarly, on the sealing side, if somebody is convicted, say, of retail theft, and they go to jail for 3 days, that's their sentence. And once they finish that jail time, then the sentence has ended. When the sentence ends, that's when the waiting period begins, and it's by law. And so when you're in expungements and you've successfully completed supervision, you have a 2-year waiting period. If you're in expungements and you have a qualified probation, once that ends, there's a 5-year waiting period. When you're in the sealings, and you finish the sentence. So let's say, for example, it's a battery conviction and the person is sentenced to 1 year of regular probation or 1 year of conditional discharge. Once that sentence has finished, there's a 3-year waiting period. And these waiting periods are meant so that nothing can happen. They have to wait until after that waiting period. And once the waiting period is over, the person can ask the judge to either expunge or seal the record. There is, though, an exception to the waiting period. And I always like to share this because it's really something that people would need to do before the sentence ends. Specifically, while they are in their last sentence, if the person obtains an educational certificate or a career certificate to help them move on with their career, to move past this criminal incident, if they've successfully obtained an educational or career certificate during their last sentence, they can ask the judge if the judge will waive the 3-year waiting period. So if somebody is still within their sentence, there's nothing you can do. And what we advise folks is call us back after you've completed your sentence. So if they've got a pending case or if they're within their sentence, there's really nothing they can do, and they need to just finish their sentence or finish the court case. But once the sentence terminates, if they've obtained an educational certificate or a career certificate before it terminates, then they are immediately eligible to ask the judge to seal their record. And one thing too that we always share with folks is that a request to seal is for all their records. So if somebody had like a retail theft from when they were 18, and then maybe they had a driving on a suspended license when they were 25, and that's all they have on their record, they need to wait until they're eligible from their last sentence before they can file a request to seal on any of their sentence. Basically, all runs together. They can't just say, well, let me take care of the one that happened to me when I was 18, and then after 3 years have passed from my later one, then I'll file a request to seal for that one. That's not the way it works. The way the law is written, you file the request to seal for all of your records at the same time. So if you happen to know somebody that just had a lapse of judgment, or just got themselves into a situation where they're in the middle of a criminal case and they've been sentenced, feel free to encourage them to look for an educational certificate or career certificate program to take advantage of while they are still within their sentence. Because once they are done with their sentence, then they will be immediately eligible to ask the judge to seal the record. So what are we talking about with these educational or career certificates? Honestly, it's very broad. The statute doesn't specify what it has to be, but what we have seen are, of course, GEDs. Somebody gets their GED during their last sentence. That's great. That will work. If they obtained an associate's degree, wonderful, that would qualify. But we've also seen other types of certificates that are not easier to get, but take less time and are often low cost or free. For example, Goodwill in Peoria has wonderful training programs that have certificates attached to them, whether it's a food server license certificate, or a forklift operator certificate, or a solar panel installer certificate. Those tend to be shorter programs. And what we do in our Ready to Work practice is we work collaboratively with our community partners that do job readiness, like Goodwill, like Tri-County Urban League. And those supportive service programs wrap around the client. So we at Prairie State do the legal work, but the caseworkers at Goodwill and Tri-County Urban League and MeTech and Navicor, they help the clients move forward with their dreams and their career goals so that they can start getting trained and getting education. So as soon as they're done with their sentence, they can move forward with their career. So once the person is eligible to file a request to seal or expunge, there is a process. And I would encourage you to refer folks to Prairie State Legal Services for that help. Like I said at the beginning, we do not charge attorney's fees. We pay our bills through grants and private donations. And currently we have a few grants that help us do this work. A shout out to Heart of Illinois United Way that has funded one of our Ready to Work programs. So that we can help individuals in this area of the law. When someone applies to us for this type of work, the first thing we do is look at their criminal record and determine exactly what's on it and what is eligible to be expunged and sealed, and perhaps what is on it that there's nothing you can do about, like a DUI, for example. Once we prepare that information, we share it with the client and give them advice on their rights and their responsibilities and their options. If they are eligible to file a request to seal or expunge in court, we help them prepare those documents. Sometimes we have the clients then file them on their own, and sometimes we help and we file those with them and represent them in the court case. Once a request to seal or expunge is filed, and it is filed into the criminal case at the courthouse, once it's filed, the clerk sends notice to the Illinois State Police, the arresting agency, and the state's attorney, and those organizations have 60 days to object. And sometimes they do, especially on violent offenses, they will object, and the judge then sets a hearing and wants to hear, why this person's life is different and why the judge should seal or expunge the criminal case. We have excellent judges here in our 10th Judicial Circuit and 9th Judicial Circuit in our footprint. And they're so thoughtful and will really listen to people, and they want to hear how people's lives have changed and why they should be allowed to move past these criminal records from the public view. At that hearing, the judge has 100% discretion to grant or deny the request to seal or expunge. If the judge says no, there is no appeal. there is just 100% discretion under the law. So the law really allows the judges to listen and make determinations on whether in this particular case, the defendant should have the case expunged or sealed. And then once the case, if it's granted, so let's say there's a retail theft conviction from 1985 that is sealed, notice is then sent of the judge's order to the Illinois State Police and the state's attorney and the arresting agency in the courthouse to impound those records because they are sealed. And those agencies have 60 days then to do that. We often encourage our clients to then get a new Illinois State Police access and review report to see that all of the records were in fact properly impounded. Now, what about folks that are not yet eligible? Let's say they did not obtain an educational certificate during their last sentence. So they are within that 3-year waiting period, but they really have moved forward with their life and they are ready to move past this and get a good job. So the other service we provide for folks in that space is called a healthcare worker waiver. So under Illinois law, certain employers, specifically in this case, healthcare employers, are required by law to do a fingerprint background check before they hire somebody for a healthcare job. And that's your nursing homes, that's your hospitals, that's your doctor's offices. So for your home health care workers, let's say somebody is trying to work as a kitchen staff in one of the local nursing homes or as a janitor or a custodial person in one of the nursing homes, they will be fingerprint background checked. And if they have what's called a disqualifying conviction, then no matter how wonderful the person is and how much the HR person at the hospital or nursing home wants to hire them, they cannot. And that is because these fingerprint background checks go through the Illinois Department of Public Health. And if the applicant has what's called a disqualifying conviction, then they cannot be hired until that record is either sealed or expunged, which is what I talked about a few minutes ago, or the Illinois Department of Public Health has granted what's called a healthcare worker waiver. And it's a 2-page application, but we find that in submitting all the material that the Illinois Department of Public Health is looking for, it's usually about 25 pages. And basically what it is a statement of how the person's life is different. And there are many disqualifying convictions. Retail theft is one we see a lot. So somebody, did something stupid and got a retail theft conviction back when they were 18, and now they're 30, and that's really the only thing on their record. Even if, they apply and the person at the nursing home really wants to hire them, they can't because they have that disqualifying conviction on their record. So these healthcare worker waivers are life-changing and really wonderful for those folks that are not yet eligible to file the request to seal because they're within the waiting period, but they've moved on with their life and they really have a powerful statement of how their life is now different. And probably the best success story I've had personally on this is a woman that I helped with a healthcare worker waiver. And it was that situation where she had one thing on her record from years and years ago, but it was a disqualifying conviction and she just couldn't get a good paying job. And all she wanted was a full-time job with benefits so she could take care of her and her kids. And the day that the Illinois Department of Public Health granted the healthcare worker waiver, that same day she got hired on with a home health company and started working full-time that day. And it usually takes the Illinois Department of Public Health about 3 weeks to review the applications and make a decision. So it is a nice process to go through for those folks who are not yet eligible for a request to seal, have a really short record, and are ready to move on with their life and gain employment. So thank you for listening to me. That's all I have on this. I would be happy to take questions, but really just the takeaway I want to give is thank you so much to the Chillicothe Public Library for allowing me to talk about legal aid with you guys, and for you to please take this back to your people in your world. And if you know of anyone in this situation who could use legal aid help, please don't hesitate to send them our way. And like I said, they can apply right there on our website that's in the chat box. So thank you, Catherine.
Thank you so much. Yeah, if anyone would like to drop a question or comment in the chat, feel free, or you can use the Q&A tool. Or if you prefer to ask your question out loud, you can click the little raise hand tool and I can unmute you so you can ask it. And if you are tuning in on Facebook, feel free to drop a question in the comments there. But do please remember that this is being recorded and it's a public program, so keep your questions general in nature, please. And while people are thinking of their questions, I know it's not an ideal situation, but if someone has had their records expunged or sealed and something else happens and they get something else on their record, is that a process that can be repeated, or is it a one-time?
It is a process that can be repeated. What could happen is that once the state's attorney learns of the new case, they could ask the judge to unseal the prior records. So that it's a possibility. And really, this is meant to be a fresh start, so that if then something subsequent happens, yes, it can resurface the old stuff. Absolutely.
And then people could request another sealing or expungement, which would seal everything plus the new stuff again. I mean, hopefully that wouldn't happen, but just
it would be 100% the judge's discretion.
Yeah.
I haven't seen that where a judge unsealed something because of a subsequent criminal case and then somebody asked again to seal it. I haven't seen that, so I don't know how the judges would look at that. What I would suggest to a person in that situation is really show the judge how your life is different, because that's really what the point of this law is.
Yeah. And you mentioned the different educational and career certificate options, and Goodwill being one of those. Are there other organizations that you'd recommend people getting in touch with to
Yeah, Goodwill is a really excellent resource here in Peoria for those educational certificates. But I was just at Tri-County Urban League recently in Peoria, and they also have some really great programs where folks can get those career certificates. And you don't have to pay a lot for them. And I usually encourage our clients, don't sign up for something that costs money, because there are free certificate programs within the community. And this would not be the time, it would be our advice, this would not be the time to go into a debt for something when, really this is a, step-by-step, baby step process. So, utilize those community partners that can help you move forward with what you need, get some training, and then, help you get in the door. Manpower is another one that will help folks get placement in jobs, so that they can just start moving forward with their life. We are blessed in this community to have so many healthcare jobs with the hospitals and the nursing homes and the home health and the doctor's offices, because a lot of folks can get in on the entry level and be, for example, a receptionist or in the custodian cleaning service, and then get a certificate to become, for example, like a CNA, and then they can get like a medical office assistant, an MOA, or they can get an LPN, and they can little by little go forward and forward and forward and end up being a nurse and so forth. So it's a wonderful track to have in our community, and we're very blessed to have it.
Great. Anyone else have questions? You must have answered everything. Well, it looks like no one else is chiming in. Do you have any last comments to leave us with?
Oh, I really appreciate the opportunity to share. Thank you, Catherine, for making this happen. Thank you, Chillicothe Public Library.
Well, it's our pleasure, and thanks so very much to you and to Prairie State for taking the time to do these presentations. It's been really interesting and informative. So
I'm glad. Thank you.
Appreciate it.
Okay.
Well,
All right.
that'll wrap it up for tonight. Thank you, everyone, and take care.
Thank you. You too. Bye-bye.